Okay, I think we can start now. So good morning, everybody. It's 11 a.m. here in Geneva. We are today going to do a short webinar on a topic that is recurring in the finance industry, which is how to get clients. You have a relationship manager who have their own network, and from time to time, their own build network is not sufficient to bring enough or to renew clients. So they have to actually try to find a way to enhance their network. And then they use specific people for that, which are business introducer, who brings businesses or brings new clients. And we will study today that relationship. In Geneva, it's a job for a lot of those people, the business introducer, to actually bring clients and make a living out of it. We'll have to just review where we are with that. Can you still use business introducer? Is still acceptable? Can you still pay people? What are the limits and where you have to be a bit careful? Then we're going to give you a little bit of example of what happened in here in the law firm with clients, where sometimes the contract were not properly done, and they came and they had some issues where they had to actually continue paying while the client was gone and everything. So we will do that. The best way is just to start with a case study, and we're going to comment that case study as we go. So imagine you have a multi-billionaire and is on a forfeit base domicile in Geneva, and he has his best friend, right? And his best friend, they speak together, and his best friend, the uncle of the best friend, so the best friend's name is Donald, the billionaire is Mr. O'Connor. Donald has his best friend, Mr. Scrooge, who works in a bank in Geneva. And Mr. Scrooge said, hey, you know, I know that you have that guy, you're close to that guy, happy to speak to him, I'm happy to propose to him my bank, my services, we're doing this and that and that. And then ultimately, Donald just speaks to Mr. O'Connor, and then O'Connor meets with Scrooge, and he's getting convinced, and O'Connor opens an account with the bank, the Credit Private Bank in Geneva, and he wires 50 million on the account, and he gets 1% for all the flat fee for all the services for the banking services. That was what was negotiated between Mr. O'Connor and Mr. Scrooge. And then Mr. Scrooge speaks to his nephew, said, hey, nephew, you know, it's great, you have good contact, you know, can I just give you a commission? Can you pay you? And then Donald says, oh, well, why not, right? So I'm going to take 50% of all what you make, so that you know, I get remunerated for my introduction. And if I find other people, I'm going to do the same. So here we have a typical case of a business introducing relationship, which is not a simple address providing, as sometimes, you know, people say, oh, you know, I need to open a new bank. I can say, look, I'm banking with UBS. Go speak to UBS. They're great people, and that's it. Which is just providing an address, and that's basically it, right? You don't get anything out of it. But here you get a triangular relationship. And why is it a triangular relationship? It's because you have a client who knows an introducer, and you have the introducer knows a bank, and ultimately the bank knows the client. And each of these three parties start having a relationship with one of the three that the other doesn't really know about, right? So the business introducers may start having a relationship with the bank. It might be that the client doesn't know about it, or knows, or barely knows, or doesn't know everything about it. The business introducer doesn't necessarily have a full control, or is not part of the business relationship that is being linked between the client and the bank. And it might be in certain cases, and that would be a sub-case study, that the business introducer has also a relationship with the client, because he might be hired to do something. And these triangular relationships are always the critical one to review, because they triggers duties that you have towards a relationship, a contractual relationship. And when you have dual relationship, then you may have a conflict of interest that arise, and you have to manage them. Mm-hmm. And this triggers question of contract law, regulatory obligation, sometimes criminal implication, and then purely, human relationship. How you may lose a client, and there's no consequences contractually except that you just lose a relationship, or you lose a friend, right? Donald may, if Mr. O'Connor knows that Donald gets a commission, he might be offended. You lose a friend. So how do you deal with it? Can you still do it? And what is the status of the law at this stage? Yes. So for that, we need to analyze a little bit what are the type of contract that binds each of the parties.
Yes, thank you. So as Dominique mentioned, there is this triangular relationship between the parties, and there is three relationships. The first relationship is between the business introducer and the end client. So it could be a written mandate agreement. It could be a wealth management agreement. We will see that later. And it could also be a kind of oral mandate. If, for instance, Mr. O'Connor just asked to his friend, okay, could you please refer me a bank, as Dominique mentioned before, there is probably a relationship which could be qualified as an oral mandate. Finally, all this triangular relationship ends with a final agreement, that's the purpose of the relation, between the end client and the financial institution. But in between, there is this business introducer agreement which bound the business introducer and the financial institution. So if we focus on that relationship, two different type of agreement as per the Code of Obligation could enter into account. First, the agency agreement, and secondly, the brokerage agreement. So the business introducer agreement has much similarities with the agency agreements, by which the agent has a right to receive a commission for the business introduced or concluded. The brokerage agreement could also enter into account, but it concerns more a single transaction, as for instance, if you conclude a brokerage agreement with a real estate broker, it's for the acquisition of a particular real estate property. And as the business introducer agreement is most of the time concluded on a long-term basis, it's most probably the agency agreement that will be the agreement, the more appropriated, and that a federal code could qualify a business introducer agreement as an agency agreement. This leads to a few problematic, because there is a lot of mandatory disposition applying to the agency agreements as per the Swiss Code of Obligation, and we will discuss that at the end of the presentation. We will make a quick review of the clause that should be added or not in a business introduction agreement. And in any case, the general rules of the mandate agreement apply secondarily, and we will also discuss that during the presentation.
Yeah, so just to come back to these different type of agreements. So you have usually mandate agreements. So agency, brokerage agreements, a type of mandate, a type of agreement called mandate agreement. They are deviation of mandate agreement. And then you have the relationship between the bank and the client, which is an asset management contract, which is deposit contract, which generally speaking also fall under the clause of the mandate agreement. And here, the mandate agreement, you don't necessarily have a duty of result, but you have a duty of good means of acting fairly and acting in the interest of your client. So that's where the issue is. In the agency agreement, something to add as well, usually you act in your name, but on behalf of a client. The brokerage agreement is typically something that you could see in a real estate transaction, a broker, where he just put two parties and then negotiate together. So in the long-term relationship of a business introducer, it's a bit of a combination of the two, which brings a bit of uncertainties in terms of result. That's why your contract needs to be clear. And most of the time, the business introducing agreement are not so well drafted. And I will give you a case of where a big issue happened once. So now you have then people bound by contracts. And then so typically two parties, the financial institution and the and the business introducer. And then we need to see who can become a business introducer. Is there a limit? Can anybody be a business introducer? And if you look at the past, anybody could be. People from the street, anybody from the street could be, a taxi driver flying from a private airport. All these rich billionaires flying in private jets could introduce, to a banker and then sign a contract as an introducer, and banks would do so. Now, no, it's no longer really the case. I mean, try to be from the street and sign a contract with a bank. The bank will say no, and most of the time they will say, well, you have to be regulated, at least at minima, for money laundering obligation. And why is that? So we just went to see in the law, and in reality, there's nothing. Certain type of business introducing requires licenses. Insurance intermediation. In certain country, real estate brokerage requires specific registration. But for financial introduction, there's not so much of a requirement, and especially if you look into the new law, which are the law on the financial services and the law on financial establishment, and the surrounding laws applying to the finance industry, there's not a specific license for business introducer, but banks or asset managers usually like to contract with a licensed entity rather than someone that is non-licensed. And the reason of that is not a direct reason, indirect reason. Is because a licensed entity has very specific duties of disclosure, code of conduct, and behavior towards their client. So it is true that when a bank contracts with an introducer that is subject to a license that has been prescribed by a regulator, there is less of a possible liability to the bank, because it can rely on the fact that that introducer will actually comply with specific duties that lies with its license, even though it's not a proper license of introducing. And that's what we have seen in the past. So no real requirement by law, but in practice, this is where the industry tend to go. It's you have to be somehow licensed at minima for money laundering requirement to become an introducer. And of course, when you become an introducer and you sign a contract, then you want to have people want to have remuneration. And so what type of remuneration? And again, you can look into the law, the specific amounts or the quantities or the way it's being paid, whether it's an upfront fee, a flat fee, a percentage on the revenues, or any type, possibly, let's imagine remuneration in kind is not necessarily set forth by law, but you don't have a specific rule on that, but you have general principles that are around this, right? And those are the one first that lies with the conflict of interest, duty of loyalty that you have. So when you agree on a remuneration, it's freedom of contract, but that freedom of contract is limited by your own duty towards all the parties that you've contracted with. So whether the client or whether it's the introducer when you pay, and the introducer to receive it, what is your own duties, towards the client and towards the financial institution, maybe, and that lies with what you have to be careful in this general. There's nothing set in stone, but in this general principle is that, is this remuneration going to prejudice anybody? Is it a standard industry? Is it way too high? Because it's way too high, we're charging way too high the client. Does he know? If he doesn't know, is it a damage to him? Am I already paid by the client? And if I'm already paid by the client, can I receive a dual remuneration? We're going to speak about that. And really trigger any civil liability, regulatory liability, or criminal liability of mismanagement of assets or private corruption. We're going to see that as well. So the definition of the remuneration, the contract, is something which is very important, and that will be part of the clause that will tell you how to draft them later on.
Yes, so this leads to the duties of the parties. If we take the perspective of the business introducer, so the business introducer can be linked by a mandate agreement with his client. So this is what we discussed before. And in this case, the business introducer generally has a duty of loyalty toward toward his clients based on the general mandate rules. Of course, the business introducer is not disinterested about the referral. We just spoke about the remuneration. So here arises a conflict of interest between the interest of the client based on the duty of loyalty and the remuneration of the business introducer. So is the business introducer driven by the interest of his client or by its own financial interest to get paid the higher possible by the financial institution? This leads to the question of the conflict of interest in the relationship. So as the general principle of the mandate rules and as per a lot of jurisprudence decision, the business introducer has the obligation to avoid any conflict of interest. That's the general rules of the mandate agreement. And if the conflict of interest cannot be avoided, they should be disclosed and authorized by the clients. So as you know, on 1st January 2020, entered into force the Financial Services Act, FinSA, and there is in FinSA a particular disposition, which is Article 25, which specifically address the problem of the conflict of interest. And Article 25 FinSA has been detailed in the ordinance. We do not want to go in too much details, but there is a whole bunch of disposition about organizational measures. But the principle of the conflict of interest regulation is that the risk should be identified, the conflict should be avoided, and if the conflict cannot be avoided, they should be properly disclosed. So in our case, the conflict of interest is realized, of course, by the payment of the remuneration to the business introducer agreement, which will be considered as per the law as a retrocessions. As you know, retrocessions are a very hot topic in the financial industry. There has been a lot of recent jurisprudence, and Dominique will discuss a very important one just after. But as per the civil law, the principle is as follows. So the agent is obliged to give an account of his agency activities and to return anything received for whatever reason as a result of such activity. So this concerns all the documentation received in the course of the mandate agreement and all remuneration. And of course, this includes the retrocessions. Mm-hmm. So there has been many jurisprudence from the federal courts, and the principle as per civil law is that the client should be informed in advance of the amount of the retrocession, and he has to waive his right to receive them. Otherwise, all the remuneration received should be passed on to the end client.
Yeah. So remember our case study where Donald is the friend of Mr. O'Connor. Now imagine that Donald is not only the friend, but he acts as an independent wealth manager. So he really has a contractual relationship and then a contractual duty and a regulatory duty of loyalty towards his friend O'Connor. And in this case, the conflict of interest is even higher because he's already paid for his services somehow, which broadly speaking would include the management of the banking relationship. And here you have to be a bit careful, because in the first example, in the first case study, you could see that, well, Donald is not paid by his friend, so it's his only remuneration, and he just gets that as a living. He never really said to his friend that he's getting paid for the service. He discovered, probably having to pay them back to the extent there was no contractual relationship. He probably doesn't have a duty to actually, he doesn't have a mandate agreement, but here he does have a mandate agreement. And everything that we said applies. So, and his duty of conflict of interest is important because if he doesn't disclose anything, being an asset manager, and if he doesn't disclose that he's getting remuneration, there has been recent court cases by the federal criminal tribunal, saying that an asset manager that received retrocession and never disclosed anything to his client is subject to criminal proceeding of mismanagement of the interest of his client. And so an asset manager has been condemned by the criminal court to a jail sentence, suspended jail sentence, and to pay everything back because he never disclosed. So if you have to choose between not saying anything, saying a little bit, just say a little bit. If you have to choose between saying a little bit and saying a lot, then just better say a lot, because then we're going to speak about the civil consequences of it, right? So, and all of that comes probably from the European Union set of rules, which are a bit in advance and in terms of disclosure and in terms of actually not only allowing to get retrocession, but prohibiting retrocession in some extent. And so the Swiss system is trying to find a way in between allowing everything and in prohibiting it by a system of disclosure, which is not working so well, to be honest, but it is the way it is. So you have to be really careful in how you deal when you are the business introducer and you have a relationship, a contractual relationship with the clients you bring to another institution. Mismanagement of as a criminal matter is a big issue, and if the bank or the paying agent, the paying party, realize that is the case, they could also be named as an accomplice to the matter, right? But worse, now you have the criminal sanction of the private corruption. Imagine you're a wealth manager and you have 3 or 4 banks, and one bank gives you 10%, the other bank 20, the other bank 30, the last bank 50% of all the commission. But you know that the last bank gives a lot because their services are not so great. I mean, it's not the best service that you could give to the client. And you select that bank based on certain facts and criteria. You could technically, we could technically think that the offense of private corruption could possibly apply to that case as it is. So you have to be really careful the way you select, and also let your client help, decide, not only propose one, but propose a series, and he's the one deciding, and you're not the one deciding for him based on your remuneration. So now in terms of disclosure, if you disclose that you're going to get retrocession, then you probably by 95% avoid any criminal offense because you have disclosed it. But if you want to keep them, then you need to make sure that your disclosure is comprehensive enough so that the clients can take an informed decision to leave them with you. And there's 2 ways of doing that. So there was many ways of doing that, but the federal court has taken decision over time. And actually at the beginning, we were just saying, informing that that the asset manager was receiving commission, that thought would be enough. And then the federal court says, no, it's not enough. He needs to be informed on the exact amounts. And then the federal laws on the federal service came into place. And now there has been a new decision on 13 May 2020 indicating a new principles. So 2 ways of doing that. Either you tell the clients, I'm taking commissions, but I'm going to tell you at the end of the year how much it was, and you will decide at the end of the year. So that means that when you receive the statement of all the commission you received plus the total, you can countersign, and then they're owed to you. But during the full year, you're never totally sure. It is not going to ask you to reimburse them, right? So what you would like to have is that you make sure that he never asks you to reimburse them because he agreed in advance. And to agree in advance, either he needs to know the exact amounts, but it's often impossible because it's usually based on a percentage of certain transactions, and you never know the amount of transaction that will happen. So So there was a point a couple of years ago where we'd say it would take 50% of all brokerage fees. But then federal court says, and the federal court issued a decision in May 2020 indicating that that is not enough because a client doesn't know how many transactions will happen, so you don't know the exact total amounts, right? It's impossible for him in advance to know what is the size of the remuneration. So they said if you want to do that in advance, you have to actually put a maximum percentage on the assets under management, on the total assets. If Mr. O'Connor wired 50 million, saying, okay, I'm going to take retrocession, Mr. Donald, I'm going to take retrocession up to 50% of your total asset under management. So he knows that it is going to be 2.5 million, more or less, right? So it could be less, but not more. And that is then something which is precise enough for him to say, okay, well, you have 50 basis points here, but you're charging me already 75 basis points on your management. I believe it's too much, so I disagree with it. And so that would be that's the current principle of disclosure that needs to be done. If you want to make sure that you're not, I mean, as a business introducer, that you don't have to repay them, right?
Mm-hmm. So the principles that have been discussed by Dominique have been implemented in the FINSA as from 1st January 2020. So as per Article 26 FINSA, the financial service provider may accept compensation from third parties only if they have expressly informed the clients of such compensation in advance, and the latter waive such compensation, or of course, all the remuneration should be passed to the client in full. Article 26 also precises what kind of information should be given. So all the principles just discussed have been implemented in the law. And the information must contain the type and scope of the compensation and must be given before the provision of the financial services. And if the amount cannot be determined in advance, the financial service provider should inform its client of the calculation parameters.
Yeah. So here the law says if the amounts cannot be determined in advance, mm-hmm. the financial service provider shall inform its client of the calculation parameters and the ranges. Mm-hmm. And so the federal court indicated that it needs to be based on the total AUM, exactly. Right? So 50 million, how many percentage of that will you do? Even if you do, it's a percentage based on transactions, it should be, the client needs to understand the parameters and the ranges, and that is based on the asset under management. So now let's speak about certain always in when we speak about conflict of interest. Imagine that we have Donald, and Donald did not really indicate to his best friend, Mr. O'Connor, that he received commission, and O'Connor realized that he's paying 1%, and that 50 basis point goes to Donald, and he disagrees with that. And then he goes to the bank and says, hey, you are actually paying 50 basis point out of my 1% to my best friend, and I never agreed to that. So that also means that you agreed to work for 50 basis points. So, charge me only 50 basis points. I mean, otherwise I'm going to sue you. I'm going to terminate the relationship. And Mr. O'Connor is a big client for the bank. The bank doesn't want to lose that client. It's a big multi-billionaire. He put already 50 million. Maybe there would be more money to come. But the bank has now its contract with with Donald. And then Donald, if he doesn't get paid, can go to court and sue the bank to get his money. So how do you deal with this? And of course, it's very delicate, because if your contract says, I'm paying you whatever I receive 50%, and then on the other hand, the client discovered, he says, I refuse that you pay, you're breaching a number of duties. I'm not going to list them, but contractual duties you don't pay. If you don't follow the order of your client, then he might file a regulatory complaint against you. You might lose it. I mean, all sorts of things that you don't want to deal with. So that's why it's very important that your contract is being drafted properly. and managing the interests of everybody. So that was a specific case we got to have to deal with in the firm here. And obviously there was no solution except to sit with the client and try to find a solution and put the party and actually try to negotiate between the introducer and the client themselves so that they get an agreement. But the reality is we had to redraft those agreements, and here you need to indicate specific terms in your agreement where you manage the interests of your own client. That means if the client doesn't want you to pay anymore, you may want to have a clause indicating that you will stop paying. Mm-hmm. And especially because you also have in that agreement a clause saying that your business provider has a duty to inform the client that he received this commission. So if he hasn't done so, and if he hasn't agreed to it according to your contract, then and the client just is unhappy about that, then you must have the right to terminate payment. And of course, it's a bit unfriendly to business introducer, but between being unfriendly to business introducer and breaching your duties and having to pay something that the client doesn't want you to pay anymore, or worse, cut his fees, you better select the first option. Mm.
So we discussed about what are the obligations of the person receiving the remuneration, receiving the retrocessions. What are the obligations of the financial institution who pays the business introducer fees? There has been a recent court decision rendered on 28 April 2022. So it's it was yesterday, and. Apparently, according to this decision, there is no obligations of information based on the general mandate disposition as per the Code of Obligation. However, FINSA does not mention specifically the duty to inform for the financial institution who pays the retrocession to the client. However, there is, of course, a general duty of information that are imposed to the financial service provider, and we think that based on this disposition and based on those principles, the information should be given to the client, meaning that the fact that the bank, for instance, pays the retrocession should be documented in the agreement and in the documentation between the bank and the client or any other financial institution. As Dominique said before, we really think that more information is really better. It's always better to inform more than what is required.
So the business introducer has a duty to inform the client that is receiving retrocession. The paying agent, the financial institution, based on that recent court decision, which is only based on the Code of Obligation, not on regulatory obligation, says it is the paying person doesn't have an obligation to inform the client. And if the client wants to ask and do a reddition de compte, a request of information to the bank will not have to say. But be careful that this decision doesn't take into account any regulatory obligation. It's purely based on Code of Obligation contractual relationship. Now, if you ask my opinion, seeing how FINMA goes, how auditors, and we love auditors, and internal auditors, external internal auditors, they are, the reality is that a financial institution is licensed based on a couple of principles: acting in good faith, l'activité irréprochable, so the impeccable activity, and duty of loyalty. So I would be very surprised that FINMA would not request, if it was imposed to financial institution, to disclose the retrocession. And why I'm saying that is that a couple of years ago, FINMA did send a letter to all banks saying you have to inform your client if you're paying retrocession based on their assets. So it was before the entry into force of the Financial Service Act, but it is the mood of FINMA, right? So it's a court decision, that says something, I'm not sure it completely applies to regulatory duties. Huh?
Exactly.
So you have to be careful. So now we're just gonna finish that webinar by telling you what we believe the clause should be in your and just to brainstorm a little bit about the clause in your referral agreement, right?
Yes. So at the beginning of the presentation, we explained that if the business introducer agreement is qualified as an agency agreement, that could cause a few problems to be addressed. Actually, there is one question that should be raised regarding the exclusivity of the business introducer. If you give a specific exclusivity to your business introducer for a specific area or a specific type of clientele, you really must be careful, because he will have the right to his remuneration in the specific area and for the specific client, even without his or her intervention. So if you want to leave this, that's fine, but that's something to think about, and maybe to just remove the exclusivity of the business introducer.
And frankly speaking, I would tell you never do an exclusivity. The reality is that if you are a financial institution abroad and you have a business introducer with an exclusivity clause here, you expose yourself of potentially being a business, an introducing broker, and which will trigger also other regulatory duties for you as a bank with FINMA. So just avoid exclusivity.
Yeah, exactly. Also, the business introducer is an independent contractor. This seems to be logic, but of course, since it needs to be written in the agreement that your introducer is not an employee of the financial institution. Question should be
in this one, if I can add, and especially when you look at the Uber court decision now. It is true that if a business introducer just work mainly with one bank and get the majority of his revenues out of one bank, you need to make sure that he's properly registered as an independent person, because we have seen the case where where an asset manager at all of us had to pay social charges on all the commission he paid because it was a unique relationship.
Yes. Also, you may want to precise a bit the scope of the introduction. For instance, if the financial institution only onboard institutional client, you may want that your introducer makes a preliminary checks on the categorization. Any AML pre-checks, of course, you do not want your introducer to bring you people that are not proper in respect of AML, or for instance, exclude any client, as if you do not want like US clients. This should be mentioned in the business introducer agreement.
So you also want to make sure that you keep control as a financial institution on the onboarding of clients. So you have to clearly indicate that the final decision to onboard, whatever reason is, based on your risk appetite, but based on any other reason, lies with the bank or with the asset manager. You should not leave it vague. Otherwise, you may be ended up refusing a client, and the introducer sues you to pay a commission because he did bring you the business. He was supposed to do so. So then you may want to make sure that it's not an agency agreement. So clearly indicate that the business introducer has no right to conclude on behalf of the financial institution. For the insurance intermediation, some insurance intermediaries conclude directly for the insurance. That's one thing, but in the finance industry, you need to make sure that, especially with the categorization of clients and the AML requirement, that if the business introducer conclude on behalf of the financial institution, it doesn't free you from your requirements to actually do your proper check of the client, and so never let a business introducer sign on behalf of the bank, of the asset manager. And then basically the formula of the remuneration needs to be clear. And here you need to be clear on where you pay and what you pay, because we have also seen the case where a financial institution had to pay a percentage of revenue that actually the bank was not able to collect. And so you have to indicate clearly that it's based on collected money, that the scope, the exact scope of the revenues, VAT, not VAT, because you charge banking fee without VAT and then you pay with VAT. So who is having the burden of the VAT? And also making sure that at any moment, if in terms of the range of the remuneration, if the remuneration becomes outside of what the regulatory framework allows to do, that you have a right to change it. And this is something, it's not written in the slide, but that's something that you have to indicate in your contract, that you need to be able to change the parameters based on the regulatory requirement that you have to avoid being civilly sued by the introducer, but having a counterburden from a regulatory standpoint.
Regarding the remuneration, there is another important mandatory provision from the agency agreement that could apply, is that the agent has a mandatory right to consult the books and the other supporting documents that are relevant to calculate his or fees, especially when he is paid by a percentage of, for instance, the asset under management, or a percentage of the fees paid to the bank. How do you deal with this when you have a banking or FR secrecy? So it's very important to add in the agreement that, for instance, the business introducer allow a third party to go see the accounts, for instance, the auditors of the company or a judge, and this will have to be agreed in some way by the end client.
Yeah, and then of course, when can you stop paying? It's important to indicate when you can stop paying. So you have to be able to stop paying if the client clearly indicate that he disagree with it. Mm-hmm. And the way you get out of it is because he disagree with it because he was not properly informed by the introducer. In this case, the introducer is in breach of his duties. He misled you. You may have to stop paying if a conflict of interest arises which were not foreseeable at the beginning and is unmanageable, without having and of course, if the regulatory framework changes and prohibits you to pay, you need to be, but you have to clearly indicate that in your contract. Time limit of the remuneration, when you stop paying it as well. If for instance, the client or the business introducing agreement is terminated, what happens with the client that remains with you? You have to make it clear. And then you need to make sure in that contract that you put obligation on the introducer. That means that is, even if you would a contract with a non-licensed entity, that is obliged to inform the client, that is obliged to make sure the client agrees, that he manages all the possible conflict of interest with the client, and that it's a transparent relationship, basically. So if you have all of that in there, and drafted properly, then you're probably safe. Huh? So that's probably what we wanted to say today. I don't know if there is